Longsetter of the Philippines versus Quezon City, GR number 144104, June 29, 2004. Facts of the case. Petitioner, Longsetter of the Philippines, is a non-stock non-profit entity. Is the registered owner of a parcel of land located at the Quezon Avenue corner Elliptical Road, Central District, Quezon City. The petitioner accepts paying and non-paying patients. It also renders medical services to outpatients, both paying and non-paying. Aside from its income from paying patients, the petitioner receives annual subsidies from the government. On June 7, 1993, both the land and the hospital building of the petitioner were assessed for real property taxes. Petitioner filed a claim for exemption of real property taxes, claiming that it is a charitable institution. This was denied, hence a petition was filed with the LBAA. Petitioner was alleging that under Section 28, Paragraph 3 of the 1987 Constitution, the property is exempt from real property taxes. It averred that a minimum of 60% of its hospital beds are exclusively used for charity patients, and that the major thrust of its hospital operation is to serve charity patients. The petitioner contends that it is a charitable institution and as such is exempt from real property taxes. The QCLBAA rendered judgment dismissing the petition and holding the petitioner liable for real property taxes. The QCLBAA's decision was likewise affirmed on appeal by the Central Board of Assessment Appeals of Quezon City, which ruled that the petitioner was not a charitable institution and that its real properties were not actually, directly, and exclusively used for charitable purposes. Hence, it was not entitled to real property tax exemption under the Constitution and the law. The petitioner sought relief from the Court of Appeals, which rendered judgment affirming the decision of the CBAA. Thus, a petition was filed to the Supreme Court. The issue here is whether the real properties of the petitioner are exempt from real property taxes. The court ruled that no. The court held that portions of petitioner's real property that are leased to private entities are not exempt from real property taxes, as these are not actually directly and exclusively used for charitable purposes. The settled rule in this jurisdiction is that laws granting exemption from tax are construed strictissimi juris against the taxpayer and liberally in favor of the taxing power. Taxation is the rule and exemption is the exception. The effect of an exemption is equivalent to an appropriation. Hence, a claim for exemption from tax payments must be clearly shown and based on language in the law too plain to be mistaken. In order to be exempted, the petitioner is burdened to prove by clear and unequivocal proof that A, it is a charitable institution, and B, its real properties are actually, directly, and exclusively used for charitable purposes. What is meant by actual, direct, and exclusive use of the property for charitable purposes is the direct and immediate and actual application of the property itself to the purposes for which the charitable institution is organized. It is not the use of the income from the real property that is determinative of whether the property is used for tax-exempt purposes. Hence, the petitioner failed to discharge its burden to prove that the entirety of its real property is actually, directly, and exclusively used for charitable purposes. While portions of the hospital are used for the treatment of patients and the dispensation of medical services to them, whether paying or non-paying, other portions thereof are being leased to private individuals for their clinics and a canteen. Further, a portion of the land is being leased to a private individual for her business enterprise. Accordingly, we hold that the portions of the land leased to private entities as well as those parts of the hospital leased to private individuals are not exempt from such taxes. On the other hand, the portions of the land occupied by the hospital and portions of the hospital used for its patients, whether paying or non-paying, are exempt from real property taxes. In light of all the foregoing, the petition is partially granted. The respondent, Quezon City Assessor, is hereby directed to determine after due hearing the precise portions of the land and the area thereof which are leased to private persons, and to compute the real property taxes due thereon as provided for by law.